Hello, Iowa Realtors, back with another legal breakdown video as part of our series, Disclosure, Duties, and Dilemmas. George, this is a topic. The topic we're going to talk about today, we're going to start with this question. Okay. Let's start it this way. Have you, George, in all your years of practice, ever had somebody tell you, well, you know, I don't need to deliver a seller disclosure statement because I've never actually lived in the property?
Yes, Gabe, many times.
Yes.
You know,
yeah.
And more recently, more times.
Yeah.
You know,
yeah.
The way the market is now, I find a lot of people buying property and flipping property.
Yes.
And you know, they buy it and for a month or weeks or whatever, they renovate it.
Right.
Comes time to sell, they have the seller disclosure. I don't need to fill it out.
Yeah.
Put an X through it. Whatever, and feel that they don't have that obligation. That's where the issue comes in.
Well, if you've ever found yourselves in one of those situations or heard that or ever wondered, man, if I haven't lived in the property, if I'm just flipping it, if it's just my rental property, I've never lived in it, do I need to fill out a disclosure? Can I just put an X through it? If you have ever considered that question, you need to hear what we're about to say today.
Be careful.
There was a case, George, there was a case in Iowa. Just to tell you a few facts of this case, essentially there was a real estate agent who was an agent for 33 years that happened to own several rental properties, okay? One of those rental properties went to go list it, okay? And as they're going through the walkthrough of this property, this person whose rental property this was, the listing agent, you know, points out, hey, we've got a little bit of an issue here, a little bit of an issue there, points out a few things, but just a few issues, right? And when they go to deliver the seller disclosure statement, essentially what this listing agent did was placed a large X over the text of the seller disclosure form and wrote, sellers never lived in the property, right? The theory was, we've never lived in this property, we don't know anything about it, we are just going to put an X through the seller disclosure form, okay? Well, buyer ends up purchasing the house, and when they purchase this house, there's all kinds of issues that unfold, right? Wet spots within 6 months on the basement walls and floors. I believe we're talking about mold issues. We're talking about inches of water in the basement. Eventually, water started to penetrate the walls and the main floor of the home. Come to find out that there was a septic tank that was buried outside, sewer line issues. All these issues, George, they find out after this property had transferred, right? And of course, what did they do? They sued the listing agent.
Of course they're going to do that, Gabe, and I'm kind of surprised. 33 years in the business?
Yeah.
Right?
Yeah.
Didn't feel that they needed to fill out a disclosure.
Well, actually, in this case, what's interesting is, according to the case, the listing agent or somebody testified that they had learned at some point or thought they had learned that it was customary in the industry to just put an X through a seller disclosure. They didn't learn that in your class, did they?
No, they did not in my class.
Certainly not in my class either, right?
Right.
Because, right, when you go to 558A, there's nothing that says that if you haven't lived in the property, you're exempt. It says that you have a duty to disclose any actual knowledge of any material issues you know about the property, or make a reasonable inquiry to obtain the information, right?
Right. What if there were issues that occurred prior that you've been made aware of, but they've been remediated?
Yeah, and that's interesting too, because if you remember from a previous video that we did about a whole year ago, we talked about that snake case, right, where there were a bunch of snakes in the house. And that was Welp versus Robinson, Robinson versus Welp. And essentially what that case stated was that you do have an affirmative duty to disclose any knowledge you have about past issues with the home. So you can't say, well, it might have been an issue 2 years ago, it's not an issue now, so I'm not going to disclose. You need to disclose any information that you know about that property. If it was an issue in the past, you have an obligation to disclose it.
Yeah. And Gabe, there's another case that I recall that where the agent did not inform their client, their buyer client, that the disclosure was not fully completed.
Right.
And you know, later on there was an issue with that.
Have an obligation to make sure that that's completed. Absolutely. You're never filling out that form for a client.
No, never.
You're never putting pen to paper or anything like that. But hey, you know, it looks like something's not quite filled out on here. Yeah. Or as a buyer's agent, yes, there shouldn't be an extra this. Let's see why they're not disclosing this. Let's ask them some more about that. Let's ask them to update this.
Exactly.
Absolutely. So I think those are the key takeaways, right? That you don't just put an X through it. You have an obligation to disclose what you know. People who are flipping houses, People who are selling rental properties, you need to be aware, even if you have not lived in the property, that does not in and of itself exempt you from filling out a disclosure.
Exactly. Good faith and honesty are key.
Awesome. Great topic. Thanks again, viewers. We'll see you next time.